Now I give the floor to Professor Dimitrios Kyriazis, who is assistant professor in Thessaloniki, in a very distinguished university here in Greece. Distinguished state aid expert, my colleague Professor Kyriazis, and I was also happy to highlight that, among others, he possesses this kind of expertise in his recent tenure proceedings, and we are happy to have him in the broader Greek academia. Professor Kyriazis, you have the floor.
Thank you very much, Professor Metaxas, both for your kind words and for your very kind help so far, and for the invitation. It's a great honor and pleasure to be among you today, to be on this panel as well with distinguished colleagues. My topic will be very specific. I want to focus on the tax aspect of energy law and of state aid environmental taxation, let's say. And I want to wonder in these few minutes we have together whether we're witnessing a return to national fiscal autonomy. Now, any discussion about energy tax and state aid or environmental tax and state aid will necessarily revolve around fiscal state aid, because it's the fiscal state aid case law of the Court of Justice that has given us the principles that we apply to energy state aid and environmental state aid. I have grouped them together. I will refer to either one, energy or environment, but as you know, they go hand in hand, both in the Commission guidelines and usually in court case law. So it's very interesting to note the interaction of energy environmental taxes with EU state aid law. It's a relationship that raises some awkward questions because various interests conflict. One, let's say, member states' regulatory choices, EU intervention, consumer interests, business interests, but also especially environmental protection versus an undistorted competition between undertakings, and many other, let's say, objectives like energy autonomy or energy solidarity. There are many things that come into play that are difficult to reconcile with the pure, let's say, competition goal of 170 FEU. Now, both member states and the EU have set many ambitious energy and environmental goals. And to be fair, energy taxes, like environmental levies, are a very good way of achieving some goals, because you might get a change in behavior by taxing a certain activity, but this might also distort competition, because this way you are channeling funds into a certain direction, let's say towards energy-intensive users, or away from them, or towards users that pollute the environment, or away from them. And this way you are putting the hand of the state in the market, which is tricky in the sense that if it's selective, if it gives an advantage, the state aid prohibition will apply. But taxation also has another advantage for member states. It's not about giving money. It's about not collecting money. It's not like giving a check. It's like giving a tax deferral or a tax exemption is easier for most member states, especially smaller member states, because they might not have the budget to give money, but they have, or they feel they have, the luxury of not collecting some money. And also, lastly, to be honest, it's a way to give state aid in a covered manner rather than directly. Now, the interaction with energy law and environmental law, it's very clear in primary EU law, and I will skip those slides. I just have them here because I want to show you that there are horizontal provisions that apply to 107 TFEU as well, but we also have to use the Commission's discretion here, right? It's 107.3, especially C, about environmental protection, and this has been expressed very well in Commission soft law. I won't go there because the previous speakers both analyzed a lot of soft law and very, I think, eloquently. So I will skip CSAF and I will skip all the guidelines. I want to go straight to the definition, because for anything that is fiscal aid related, general fiscal aid, tax energy, levy of energy, levy of environment, it all comes back to selectivity essentially, because usually there will be an advantage. State resources, imputability, distortion of competition, effect on trade. So there's only one potentially missing that can salvage the measure from the perspective of EU state aid law, and that's selectivity. Here I've taken the paragraphs from the notice of the notion of aid, but let me show it to you schematically. What is the schema? 3 steps. Let's say you have an energy tax on certain users. First, you have to find the reference framework. What is the main tax, the normal tax? Then you have to see if there is a derogation, meaning is the energy tax difference between some users treating similar situations differently? If yes, there is a derogation, there is prima facie selectivity. Third, is there a justification? Here the burden of proof is reversed. That's very tough for member states to disprove, and thus usually prima facie selective measures are also conclusively selective. However, and that's what I will show you before the end of my presentation, there has been in the past few years, and even this year, a bit of a return to national tax autonomy on the definition of the reference framework and also the definition of derogations, based on which we could extrapolate and apply this to energy tax and environmental taxation. Now, external objectives, let's say environmental, energy objectives, cannot help us in the third step. I make the measure non-selective. They only apply to the compatibility of aid. So you have to first have state aid for you to then argue before the Commission that it's whatever compatible with the internal market because it serves the energy union or whatever. But let's look at the structure of particular levies, taxes that are particularly on environment or energy goals. Here, the fact that you impose a levy on some activities, but you do not impose a levy on other activities, doesn't automatically mean there is a derogation. It's not like having a tax and then having an exception, and a levy that is specifically based on certain elements might be, as the Commission says, the levy might be the reference framework itself, might be a self-sufficient form of giving tax measures another spin, so to speak. Now, energy and state aid has contributed to the definition of state aid. All state aid lawyers would know the Andrea Vian case. That's an energy case, essentially. And from the Andrea Vian case, we have the basic selectivity test that we still apply today. What is it? Look at the end of the slide. The comparison with other undertakings which were in a similar factual and legal situation in light of the objective pursued by the measure in question. So Andrea Vian gave us a very specific direction, which is you look at the goal of the tax and of that particular measure and of the goal of the member state. And from then on, do you judge the comparability of two undertakings? Not the comparability in general, but their comparability in light of the goal pursued, which for a tax, for a levy, could be a certain discouragement or encouragement of a particular activity. Ecological considerations could theoretically justify it, but not automatically. We have more case law here, British Aggregates, another famous case, saying that the need to take into account environmental protection, or let's say an energy goal, cannot justify excluding selective measures from Article 107. Yeah, but what the ECJ should have said is not automatically. It might justify them, as we will see in later case law, but it will not happen automatically. You cannot simply say, I am serving an energy goal by taxing two activities differently, and therefore this measure is not selective. It might still be selective and need justification, but it might not be, depending on how consistent certain criteria are applied. And that's why I have some Spanish regional environmental tax cases that I've spotted from, and that you know already, from 2018. I'm going to just analyze one because they're very similar. And I want to show you the deference, the respect showed by the European Court of Justice to certain national tax choices related to environmental protection and to energy, let's say, consumption. They're important because they touch upon regional taxation in a sense. They're very sensitive, but the key thing was obviously selectivity. Let me actually show you the measures. They were about Catalonia, Asturias, Aragon, and they all introduced regional taxes on very big malls, large retailer malls. And the stated objective was to counter the effect that these big energy consuming malls, very big pollution producing malls, shopping centers had on the environment. So what was the measure? There was a tax on large retail establishments because they produce adverse effects on the territory and the environment, the cost of which they do not bear. How was the tax triggered? If the sales area was greater than 2,500 square meters. So size was the objective criterion. Size was the criterion for the imposition of the tax. A very big mall would pay the tax. A bit of a smaller mall would not pay the tax. Now, obviously, a seasoned state aid lawyer would say that's a very arbitrary criterion. What's that about? Is that objective? Is it arbitrary? Why not 2,400? Whatever. So this is how it worked. There was an exemption if you even if you occupied more than 2,500, if your goal and your industry was you had a very large garden or you had certain whatever activities that justified you occupying a lot of square meters, and you also had a reduction if you were selling furniture or other things where you needed to showcase them and thus this got a lot of space. So the measures that were potentially sources of state aid trouble, fiscal state aid, was the non-taxation of establishments that were smaller, the exemption from taxation of certain establishments that exceeded that amount, and the reduction of tax for certain establishments that exceeded that amount. So three potential sources of trouble of selectivity in the non-taxation or the reduced taxation of certain malls, of certain shopping centers. Now I'm going to take you straight to the key paragraphs. I'm going to skip most of them. Look at 52. The purpose of the tax is to contribute towards environmental protection. Here we could have replace that with energy self-sufficiency, another, let's say, legitimate goal of the EU. Now the ECJ accepts that how much you pollute depends largely on your size. The bigger the size of the mall, the bigger the pollution. That's what the ECJ says. Consequently, the criterion of size, which seemed perhaps arbitrary to some, is consistent, the ECJ said, with the objectives pursued. So, such a criterion is okay because it differentiates between undertakings that are not the same, and thus it's not selective because you are treating different situations differently, not similar situations differently. Therefore, there was found to be no selectivity, no selective advantage. And I add one paragraph from the Asturias judgment, which is not found in the Catalonian case. Look at paragraph 48. The determination of the threshold, so 2,500 or 2,400 or whatever, comes within the discretion of the national legislature, so deference, and is based on technical complex assessments that the court only has limited powers to review. So if it's not manifestly inappropriate as a criterion, it will be allowed to stand. Deference showed in fiscal state aid cases, which is very rare for the European Court of Justice, or at least it was very rare in 2018, and therefore the Spanish regimes were found to be valid, to be neutral, not to give state aid, thus they were not abolished, they were found to be okay, despite the criterion purely based on size. Think about it, because this could also help a lot in the design of national energy taxes that could differentiate between undertakings on the basis of a criterion of size, as long as it's not completely, out of touch with reality. What are the conclusions from these cases? That the ECJ does check whether the scope of the measure is consistent with the objective, obviously. The non-taxation has to be, consistent with the taxation. However, the court might be very rigorous in its examination or might show deference. Some people say that these cases were sensitive and the regional authorities were given deference because of the system in Spain of the constitutional layers of government. Perhaps in a non-federal state, the ECJ would have been stricter. In my view, I disagree. I think it would have been the same outcome. One more case, and then I conclude. I promise I will stick to the time. This case from this year, although it's not on energy state aid, it is on fiscal state aid, however, and I think it could apply to energy taxation in the future. It's a very generous ruling towards member states, because in President Miasta Mielka, the Grand Chamber of the ECJ told us on the 29th of April this year, that the general and abstract exemption is not to be classified as state aid. Meaning, if you have a rule and you have an exception, and the exception seems to be general and abstract and open enough, it will be added to the reference framework and it will not constitute a derogation. Why? And this is something that helps us, because states, through direct taxation, they do not only pursue budgetary objectives, but they also pursue other objectives, which are the objective of the reference system. So the ECJ is accepting the fact that tax is not only about collecting money, but it might also be about discouraging energy usage or environmental pollution. And all of this taken together might form the objective of the measure, which is something that helps member states, because it is in the light of the objective that the selectivity comparison on the second step will take place. And the ECJ here is actually very correct, I think, because if all of this was selective automatically and every exception was a derogation, everything would have to be notified and would have to be approved by the Commission. So the Commission would substitute member states' judgment in taxation. That's a correct finding, in my humble opinion, and in line with the Fiat and the Angie cases that are also fiscal state aid cases. So the conclusion here, this was a property tax, as I said, it wasn't an energy tax, but I think we can extrapolate. The conclusion here is that an exception is not automatically derogation. Sometimes exceptions might be part of the reference framework. How do we reconcile this with other case law, like Spanish goodwill, also a fiscal state aid case? I don't think it can be reconciled. I think it's a reversal, of course, by the ECJ, which is good, because Spanish goodwill was overly broad. It almost introduced behavioral selectivity. And I think perhaps Miasta Mielka, which is also Grand Chamber, right, cannot be combined with the Spanish goodwill case. It probably is about limiting the effect of Spanish goodwill and going more into a deferential mode, giving more deference, more respect to national tax autonomy, and in this way, being compelled to agree. Overall conclusions, and I stop here. Member states' tax autonomy remains the norm, even when pursuing energy or environmental goals. However, it is threatened, of course, by several parts of EU law. State aid law is the key threat here. But the ECJ has demonstrated deference in the last 5 years. Anged, Asturias, Aragon, Miasta Mielka, in principle accepting, first of all, that not all tax exceptions are automatically also state aid derogations, and thus selective and need justification. And second thing that the ECJ has accepted, it has forced the EU Commission to accept member states' interpretation of their own tax law, as long as that tax law, let's say an energy levy, is consistent with the provisions wording and doesn't go against national case law and national administrative practice. Therefore, what the themes are national tax autonomy, but also consistency, and consistency seems to be key. Thank you very much for your attention.
We thank you very much. You highlighted in a very, let's say, transparent manner the let's say, the tensions between tax autonomy and the need for effective state aid control, because sometimes, on the other hand, state aid control is somehow also a tool in the hands of the European legal system and the European Commission to somehow also intervene in certain, let's say, measures adopted by the member states that also have a character of a more international cooperation with third countries and third countries' corporations, etc. And I also thank you very much for, let's say, bringing me back to the to my years in Berlin, where I chose state aid as a thesis, as a subject of my PhD thesis. It was a very eccentric decision back then, even for German standards. And Adria Wien was British aggregates were back then the latest case law. So it's a bit also melancholic, because I have witnessed things that were actual then, but now it's somehow the history of tax-related state aid legislation. So it's Thank you very much. Professor Kyriazis, I would really also like, and I underline that, your contribution also to the scientific publication that will follow. But I'm sure that we will have the chance to discuss about that. Thank you very much once again.